Hello everyone, welcome you all on my YouTube channel. Today I am going to discuss about the classes of criminal code which is given under Code of Criminal Procedure and Bhartiya Nagrik Suraksha Sanhita 2023. So in this we will firstly talking about the section number 6 of BNSS and section number 6 of CRPC and section 4 of BNSS, which is talking about the classes of criminal courts. So earlier there were provisions regarding the metropolitan courts, but now those sections have been omitted, and now we have only four courts of criminal courts. First is Court of Session, second is Judicial Magistrate first class, third is Judicial Magistrate second class, and then we have executive magistrate. So we will also look on the pair provisions of these sections for the better understanding. Section 6 of BNSS is talking about the classes of criminal courts. So it says like besides the High Court and the courts constituted under any law other than this Sahita, there shall be in every state the following classes of criminal courts, namely the Court of Session, Judicial Magistrate of the first class, Judicial Magistrate of the second class, and Executive Magistrate. Now we have second provisions regarding territorial division, which is given under Section 7 of CRPC and BNSS. So, territorial divisions. In the territorial division, we have their provisions like every state shall be a session division or shall consist of session divisions, and every session division shall, for the purpose of this Sahita, be a district or consist of district. Means a state have sessions or session divisions, and every session division consists of one district or multiple district. Now, section number 7, clause 2 is talking about the state government may, after consultation with the High Court, alter the limits or the number of such divisions and districts. Section clause number 3 of section number 7 is talking about the state government may, after consultation with the High Court, divide any district into subdivisions and may alter the limits or the number of such subdivisions. So this is talking about the alteration of the limits of the district. Now next subsection is talking about the session divisions, districts and subdivisions existing in a state at the commencement of this Sanhita shall be deemed to have been formed under this section. So this section is talking about the session divisions and the districts and the subdivisions which is already existing in a state at the commencement of the Sanhita shall be deemed to have been formed. मतलब उनको हम मानेंगे कि वो इसी section में form हुई है. Now we will look on another section, which is section number 8 of BNSS, which is talking about the Court of Session. So, in Court of Session, the state government shall establish a Court of Session for every session division. So, we know that every state has some session divisions or a one session division, and the state government shall establish a court of session in that particular session division. So one court of session in every session division, and every court of session shall be presided over by a judge to be appointed by the High Court. All the judges are appointed by the High Court, and the judge is known as session judge. High Court may also appoint additional session judges to exercise jurisdiction in a court of session. So High Court can also appoint additional session judges. Now subsection 4 is talking about the session judge of one session division may be appointed by the High Court to be also an additional session judge of another division. Okay, and in such case he may sit for the disposal of cases at such place or places in the other divisions as the High Court may direct. Means that session judge can also be a additional session judge for another division. And now subsection 5 is talking about when the office of session judge is vacant, Then the High Court may make arrangement for the disposal of any urgent application which is or may be made or pending before such court of session by additional session judges, or if there be no additional session judge then by a chief judicial magistrate, and in the session division, and every such judge or magistrate shall have jurisdiction to deal with any such application. मतलब कि जब सेशन जज का जो ऑफिस है वो वेकेंट होगा, तो जो हाई कोर्ट है वो अरेंजमेंट्स बनाएगी ताकि हम केस को डिस्पोज ऑफ कर पाए. They can appoint additional session judges, and if they are also not present, then CJM या फिर any other judicial magistrate can take over the case. Now, moving on, another subsection, which is subsection number 6, which is talking about the Court of Session shall ordinarily hold its sittings at such places or places as the High Court may by notification specify, but if in any particular case the Court of Session is of opinion that it will tend to the general convenience of the parties and witness to hold its sittings at any other place in the session division, it may, with the consent of the prosecution and accused, sit at that place for the disposal of the case or the examination of any witness or witnesses. मतलब कि जो कोर्ट ऑफ सेशन है उसकी जो सिटिंग होगी वो उन प्लेसेस पे होगी जहाँ पे हाई कोर्ट नोटिफाई करेगा, बट किसी किसी पर्टिकुलर केस में अगर कोर्ट ऑफ सेशन को ऐसा लगता है कि ये पार्टीज के लिए या फिर विटनेस के कन्वीनियंस के लिए कहीं और अगर हमें सिटिंग करनी है तो वो वहां पर भी कर सकते हैं. उसके बाद next section is subsection number 7, which is talking about session judge may from time to time make orders consistent with this Sanhita as to the distribution of business among such additional session judges. मतलब कि जो सेशन जजेस हैं वो टाइम टाइम पर जो ऑर्डर बनाएंगे संहिता के अंदर फॉर द डिस्ट्रीब्यूशन ऑफ बिजनेसेस अमंग एडिशनल सेशन जजेस. Now, next subsection is talking about the session judge may also make provisions for the disposal of any urgent application in the event of his absence or inability to act by an additional session judges, or if there be no additional session judge by the chief judicial magistrate, and such judge or magistrate shall be deemed to have jurisdiction to deal with such application. So, अगर सेशन जज जो हैं उन्हें वो प्रोविजंस बना सकते हैं किसी भी केस को डिस्पोज ऑफ करने के लिए अगर वो एब्सेंट है या फिर वो केपेबल नहीं है उस मतलब उस टाइम, तो वो या फिर वो बीमार है, कोई भी मतलब इशू हो सकता है, तो वो एडिशनल सेशन जज को ये पावर देंगे कि वो केस को डिस्पोज ऑफ करे. बट अगर एडिशनल सेशन जज भी नहीं है तो चीफ जुडिशियल मैजिस्ट्रेट और जो कोई और जुडिशियल मैजिस्ट्रेट है वो उनके पास भी वो पावर होगा कि वो उस केस के साथ डील कर सकते हैं. So here explanation is talking about for the purpose of this Sanhita, appointment does not include the first appointment, posting or promotion of a person by the government to any service or post in connection with the affairs of the union or of state where under any law such appointment, posting or promotion is required to be made by a government. मतलब कि इस संहिता में जो अपॉइंटमेंट है उसका मतलब फर्स्ट अपॉइंटमेंट नहीं है, ना ही फर्स्ट पोस्टिंग है, ना ही प्रमोशन है पर्सन का गवर्नमेंट के द्वारा, और पोस्ट नहीं है जो कि यूनियन और स्टेट के रिगार्डिंग वेयर अंडर एनी लॉ सच अपॉइंटेड पोस्टिंग और प्रमोशन इज रिक्वायर्ड टू बी मेड बाय द गवर्नमेंट. So now the next section is talking about the Court of Judicial Magistrates. So section number 9 clause 1 is talking about in every district, हर एक डिस्ट्रिक्ट में there shall be establishment as many courts of judicial magistrate of the first class and of the second class, and at such places as the state government may after consultation with the high court be notified. मतलब कि हर डिस्ट्रिक्ट में बहुत सारे जुडिशियल मैजिस्ट्रेट के कोर्ट्स एस्टेब्लिश किए जा सकते हैं. JMFC फर्स्ट क्लास, जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास, जुडिशियल मैजिस्ट्रेट सेकंड क्लास, जैसा कि स्टेट गवर्नमेंट हाई कोर्ट से कंसल्ट करने के बाद जो भी वो नोटिफाई करते हैं उस हिसाब से. प्रोवाइडेड दैट, सो हेयर इज अ प्रोवाइजो which is talking about provided that the state government may, after consultation with the High Court, establish for any local area or one or more special courts of judicial magistrate of the first class or of the second class to try any particular case or particular class of cases, and where any such special court is established, no other court of magistrate in the local area shall have jurisdiction to try any case or class of cases for the trial of which such special court of judicial magistrate have been established. मतलब कि जो स्टेट गवर्नमेंट है वो हाई कोर्ट से कंसल्ट करने के बाद एस्टेब्लिश कर सकते हैं किसी भी लोकल एरिया के लिए स्पेशल कोर्ट्स जुडिशियल मैजिस्ट्रेट और फर्स्ट क्लास के या सेकंड क्लास के किसी भी केस को डिसाइड करने के लिए। और वेयर एनी सच स्पेशल कोर्ट इज एस्टेब्लिश, जहाँ पे भी स्पेशल कोर्ट एस्टेब्लिश हुआ है, कोई दूसरा कोर्ट मैजिस्ट्रेट का उस एरिया में उस केस को ट्राई कर सकता है, नहीं कर सकता है। इसके बाद subsection number 2 is talking about the presiding officer of such court shall be appointed by the High Court. And subsection number 3 is talking about the High Court may, whenever it appears to it be expedient or necessary, confer the power of judicial magistrate of the first class or of the second class or any member of the judicial services of the state functioning as a judge and civil court. हाई कोर्ट को कभी भी ऐसा लगता है, ज़रूरी लगता है, तो वो किसी भी JMFC पे या फिर जुडिशियल मैजिस्ट्रेट सेकंड क्लास पे ये पावर्स कन्फर कर सकते हैं कि वो दे कैन ऑल्सो बी अ जज इन अ सिविल कोर्ट, दे कैन ऑल्सो डिसाइड केसेस इन अ सिविल कोर्ट. Now, next section is talking about the Chief Judicial Magistrate and Additional Chief Judicial Magistrate. So, in every district, the High Court shall appoint Judicial Magistrate of the first class as a CJM to be the Chief Judicial Magistrate. Next subsection is talking about the High Court may appoint any judicial magistrate of the first class to be an additional chief judicial magistrate, and such magistrate shall have all or any of the power of the CJM under the Sanhita or under any other law for the time being in force. So जो हाई कोर्ट है वो जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास को ACJM की तरह भी अपॉइंट कर सकते हैं, और जो वो मैजिस्ट्रेट होंगे उनके पास जो पावर CJM के पास है वही पावर होंगे. Subsection 3 is talking about the High Court may designate any judicial magistrate of the first class in subdivision as a subdivision judicial magistrate. हाई कोर्ट जो है वो जुडिशियल मैजिस्ट्रेट ऑफ फर्स्ट क्लास को सब डिविजन्स में सब डिवीजन जुडिशियल मैजिस्ट्रेट की तरह भी डेजिग्नेट कर सकते हैं, उन्हें रिस्पॉन्सिबिलिटीज दे सकते हैं. Next subsection is talking about the subject to the general control of the Chief Judicial Magistrate. Every subdivision judicial magistrate shall also have exercised such power of supervision and control over the work of judicial magistrate, and in the subdivision as the High Court may be by general or special order specify in this behalf कि जो जितने भी सब डिविजन्स में जो सब डिवीजन जुडिशियल मैजिस्ट्रेट हैं उनके पास भी पावर होंगी कि जो बाकी जुडिशियल मैजिस्ट्रेट्स हैं सब डिवीजन में वो उनके वर्क को सुपरवाइज कर सके, कंट्रोल कर सके, एज नोटिफाइड बाय द हाई कोर्ट. Another important section, we will talk about the executive magistrates. So in every district the state government may appoint, this is important point to consider here. In executive magistrate case, state government may appoint, but in judicial magistrate, for the judicial magistrate appointment, the appointment will be done by High Court. So in every district, the state government may appoint as many persons as it think fit to be executive magistrate and shall appoint one of them to be the DM. Like in the case of judicial magistrate, one will be appointed as chief judicial magistrate, and in this case one of the executive magistrate can appointed as district magistrate. Subsection second is talking about the state government may appoint any executive magistrate to be an additional district magistrate. स्टेट गवर्नमेंट किसी भी एग्जीक्यूटिव मैजिस्ट्रेट को एडिशनल डिस्ट्रिक्ट मैजिस्ट्रेट की तरह भी अपॉइंट कर सकती है, एंड सच मैजिस्ट्रेट शैल हैव सच द पावर ऑफ अ DM अंडर दिस संहिता. और जो एडिशनल डिस्ट्रिक्ट मैजिस्ट्रेट होंगे उनके पास DM की तरह ही सारे पावर्स होंगे इस संहिता के अंदर. Subsection 3 is talking about whenever in consequence of the office of the district magistrate becoming vacant, any office succeeded temporarily to the executive administration of the district, such officer shall, pending the orders of the state government, exercise all the power and perform all the duties respectively conferred and imposed by this Sanhita on the district magistrate. जब भी डिस्ट्रिक्ट मजिस्ट्रेट का ऑफिस वेकेंट होगा तो जो भी ऑफिसर उनके बाद आते हैं उनको उनके ऊपर पावर कन्फर कर दिए जाएंगे, वो सारे केसेस को हैंडल करेंगे. Next subsection is talking about the state government may place an executive magistrate in charge of a subdivision and may relieve him of the charge as occasion requires, and a magistrate so placed in charge of a subdivision shall be called the subdivisional magistrate. जो स्टेट गवर्नमेंट है वो एग्जीक्यूटिव मजिस्ट्रेट को किसी भी सब डिवीजन का चार्ज देते हैं तो वो सब डिवीजन मजिस्ट्रेट कहलाएंगे. Subsection 5 is talking about the state government may by general or special order and subject to such control and directions as it may deem fit to impose delegated powers under subsection 4 to the district magistrate. तो जो स्टेट गवर्नमेंट है वो किसी भी ऑर्डर के थ्रू जो है क्या कर सकते हैं, कंट्रोल और डायरेक्ट कर सकते हैं, डिस्ट्रिक्ट मजिस्ट्रेट के को पावर्स डेलीगेट कर सकते हैं. The last subsection of this section is nothing in this section shall preclude the state government from conferring under any law for the time being in force on a commissioner of police all or any of the powers of an executive magistrate. स्टेट गवर्नमेंट जो है वो किसी भी पुलिस कमिश्नर पर भी पावर्स क्या कर सकते हैं, एग्जीक्यूटिव मजिस्ट्रेट की पावर्स दे सकते हैं. ओके, सो दिस इज ऑल अबाउट द क्लासेस ऑफ क्रिमिनल कोड्स. आई होप you like my video. This is all our PPTs. Court of Session, Court of Judicial Magistrate, Chief Judicial Magistrate. You can take a screenshot for your short notes if you want. Then Executive Magistrate. So this is all about our today's session. Hope you like my video. If you have any doubts, you can put your comments in the comment section. Thank you so much.